Okay, good morning, everybody. You're in first appearance court. My name is Judge Kim Teresa Malika. Today you will be informed of the charges against you, and there will be a determination if there's probable cause. Today is not your trial day. Please do not talk about the facts of the case. Anything you say can and will be used against you. You have a right to an attorney. We have Mr. Romero, who's at the main jail, and we have Mr. Reedy over here, who's in the courtroom with me, if you're not at the main jail. If you have a private attorney, please let me know when you step up to the podium. We have a couple cases at a turn, and the first one's going to be Lawrence Anthony Jefferson, who has a private attorney.
Judge, good morning. Paul Millay on behalf of Mr. Jefferson.
Okay, state, if you can announce your appearance, please.
Eric Linder on behalf of the state.
Okay, are you Mr. Lawrence Anthony Jefferson, sir?
Yes, ma'am.
Okay.
Judge, if I may,
Sure. Let me just tell him what the charges
Sure.
are first, if you give me just one moment. Sir, you're charged with career offender failure to register or provide info. Do you have any objection to probable cause?
No, Judge.
Okay, the court does find probable cause. Actually, there's a habeas not in custody. So, state.
One moment, Your Honor.
Lawrence, good morning.
Good morning.
Your Honor, the state is going to be requesting a $7,500 bond pretrial release with a GPS monitor. This is a filed case based on the Mr. Jefferson's criminal history, which includes 1998 aggravated assault with a deadly weapon. He was sentenced to 10 years in state prison as a habitual offender, PRR offender. 1994 manslaughter, violation of probation, 8-year state prison. He's also been arrested twice in the past for failure to appear in court.
Judge, if I may.
Sure.
With respect to the two cases that the state mentioned, the manslaughter case was a plea back in 1995. He also did have a trial on an aggravated assault charge, which he was found guilty and sentenced to 10 years Florida State Prison. He has done his time successfully. He's been out. Since out, Judge, he's had no issues. In fact, he's been the model person that you would want to find coming out of the prison system. He's provided me with a copy of his resume, which is quite impressive. I'll just point out the highlights, but he's been gainfully employed since being released. He actually did check in with respect to his residence with parole when he got out as far as the conditional release. What ended up happening is the place where he was residing with his wife, whom he married in 2012, the homeowner was delinquent on the payments, so he ended up getting evicted, if you will, not because of his doing, but because of the homeowner. He was forced to gather his items up. He was given access to the property just to get his belongings. He actually went to BSO on Broward Boulevard and checked in there with the U-Haul truck to let them know that he was changing addresses, but he didn't know exactly where he was going to end up.
When was that?
That was...
Around.
It was around, let me just make sure, 2015, July. And they basically told him, as long as you stay in Broward, you're okay. He was in plantation for about 3 months at his sister's place, and then since he's been at the same residence, which is 7760 Northwest 78th Avenue, number 205. He's been working for the same company since 2015, Future Telecom. He's done different things as far as charitable organizations in the community. He's really been perfect. He became aware of this situation, and when he contacted me, obviously I told him we need to address it. He was eager to do so. He turned himself in voluntarily. He's not a flight risk. He actually wanted to address the issue. I know he and his wife have intentions to try to relocate to Georgia, which is why all the more important he wants to put this matter to rest and behind him. He's not a flight risk. He's not at risk of committing any offenses. I would ask that you not put him on a pretrial with a monitor. He did it today hoping that he could be out and not miss work, which he's scheduled to start back on Monday as well.
Okay, give me, and I know you have something, I just want to get his address.
Sure.
It's not on the paperwork.
Of course.
I'm going to have the clerk to update your client's address. Can you give that to me?
Sure, it's 7760 Northwest 78th Avenue, Unit 205.
Hold on, because I'm writing it down. Apartment 205.
205, Tamarack, Florida, 33321. And he's been there since 2015. He lives there with his wife, Bernadette Jefferson. And Judge, as far as the bond amount, if I may, I'm asking for a $1,000 bond. I know that his wife has the ability to make arrangement with Brandy Bail Bonds today to get that posted. And like I indicated, Judge, I've been retained. He's not a flight risk. He wants to actually resolve this. He's self-surrendered.
Okay, State.
Well, Your Honor, frankly, a lot of this is hard to take at face value when he puts in a residence that since 2015, the owner he doesn't know who he is. He hasn't lived there. He didn't comply with the requirements, that he signed documents saying he is aware of them, and he just didn't comply with them. And I apologize if I mentioned it already. I can't remember if I did.
It's all right. It happens in here.
You know, he did have in 2012 a possession of cocaine. He did violate his probation, so whatever conditions Judge Siegel put him on, he was unable to comply with those as well, and ended up getting sentenced to 180 days county jail.
But he's been out of prison since 9/1/14 and hasn't had any new offenses except this.
Well, one moment, Your Honor.
And I understand his prior record. I mean, that's why he's here, because he's
Your Honor,
he's an offender.
he was out of prison and he was released from state prison in 2009. He did pick up a possession of cocaine after that. When he was released from county jail in 2014, he was supposed to satisfy requirements, and that's the whole reason why he's required to fill out this paperwork. So essentially the government can, and the state can, know where he is. That's the whole point. And if he's not fulfilling those requirements, then the state is really unable to make sure that everything is being complied with. And it really defeats the purpose.
If I may, the conditions as far as his release were finished on 9/1/2014. At the time, everyone knew where he was. He was at the address that I had indicated, which is 3040 Northwest 29th Terrace. That place did not become a situation where he could no longer reside until July 2015. So everyone knew where he was. What happened was, and I think where he went wrong, is when he was forced to leave that area, he was supposed to technically check in and actually register where his new place was. He stopped at the BSO facility on Broward Boulevard and was told, as long as you're in Broward County, you're okay. That's where he went wrong. It was a mistake. You know, he's not a flight risk, like I said. He turned himself in voluntarily, and he wants to get this resolved.
Okay. All right, this is what the court's going to do. I did put on here, clerk to update defendant's address forthwith if necessary. I notice on the booking report, it does have an address, but it doesn't on this other one. So this is what the court's going to do. The court is going to do a $1,500 bond. However, I am going to do a GPS level 2, but I am going to do an open schedule, okay?
Okay, Judge.
Thank you.
I appreciate it. Thank you.
You're welcome.
Lawrence, I'll be in touch.
Okay, let's call Zachary Mark Libman. And state if you can announce your appearance for the record.
Yes, Your Honor. Ross Wiener on behalf of the state, W-E-I-N-E-R.
Okay, and whoever is for the defense.
Who's this on, Judge?
Zachary Mark Liebman.
What page is he on?
L-I-E in the end.
What page?
He's at the end. We have a special prosecutor here.
Page 22.
22. Okay, Hector, if you can announce your appearance for the record, please.
Hector Romero with the Public Defender's Office, Judge.
Brian Reedy from the Public Defender's Office.
Okay,
Judge, I don't have any paperwork on Mr. Libman, so I haven't been able to review anything.
okay.
And Judge, he's one of the last people on the docket, so I haven't had an opportunity to speak to him.
Okay, so this is what we're going to do. We're going to take a break, and we'll be right back. Okay, sir, you have private counsel? We're trying to get a hold of him.
Okay, now you can. Good morning, Your Honor.
Good morning. You have private counsel, they're out of Miami or Broward?
He's out of Miami.
Okay.
All right, I'm trying him right now.
Okay, and then we're gonna take a person after you, sir, at a turn. We have someone here for Aisha Moreland after, Mr. Liebman. You can stand there. I'm just saying who's gonna be after you, sir.
Okay.
I just need to talk to the secretary. Hey, it's Eric Linder. Hey, do you know if Liz Rodriguez is going to be in today?
Okay, sir,
Send her an email.
Mr. Reedy was kind enough to try to get a hold of your attorney. Do you know if he knows you're gonna be in court this morning, if he's on his way, or did he indicate to you that he was gonna be here?
This just happened last night. He has no clue. I wasn't able to call him yet.
Okay, is he gonna show up if you haven't formally retained him, or
Yeah, definitely.
do you have his cell?
The number I gave you was the direct number I always call him at.
Did you get it? We didn't get a number from you over here. Did you get one from Mr. Romero, Mr. Reedy, at the jail?
Yes.
Okay,
I believe.
Mr. Reedy says he doesn't have it, yeah. Why don't you call over and give it? Make sure it's the same number.
Did I not ramble off that number?
Thank you, Hector. If you do get a hold of him, tell him he can appear by phone or come in at 1. Okay, so we're gonna go sidebar so the conversation's not recorded. Attorney's office, or actually Mr. Reedy got in touch with Mr. Schwartz directly, and he indicated that he will be here today at 1:30, okay?
Okay, thank you.
All right, so we'll reset you for this afternoon. Good luck to you, sir.
Thank you.
You're welcome. Okay, Aisha Chantel Moreland.
Ms. Moreland is here, present, Judge, at Maine. She is approaching, Judge.
Okay. All right, are you Aisha Chantel Moreland?
Yes.
All right, ma'am, you are charged with 1 count of resisting an officer without violence. There's no bond attached to that. You have driving while license is suspended, third or subsequent offense. That's as being charged as a felony, and bond is set at $750. You do have a capias, which you are going to be held no bond. I don't know when your court date is. It's not indicated on here. And you do have 2 violations of probation for misdemeanor that you're going to be held no bond as well. Any objection to probable cause?
No, Your Honor.
Okay, we do have someone here today. Miss Moreland, what is your name, ma'am?
Hi, Your Honor. My name is Tanya Miles. I'm Aisha's mom.
Okay. And can you spell your last name?
Miles, M-I-L-E-S.
Okay. Is there anything you'd like to tell the court?
I just heard what you said and that she won't be getting out. I wanted to see if there was anything that could be done. We had an immediate family member pass away and the funeral is tomorrow. I just wanted to see if there was any bond or anything that could be set for us to get her out. But
who was the family member that passed away? I'm sorry to hear that, by the way.
It's her first cousin, my nephew. He was 29. He had a heart attack. He passed away on Sunday, and his funeral is set for tomorrow at Roy Mizell Funeral Home. If there's, and I understand about the violation of probation, if there's any bond amount that could be set, we'll pay bond.
She didn't. The problem is she appeared before Judge Usan, and she didn't appear for arraignment on that.
And
she got violated. I'll let you finish. She got violated on her probation. Excuse me? She didn't show up for 2 scheduled appointments. She got arrested for grand theft while she was on probation. So, respectfully, ma'am, you know, you can go before her division judges and ask them.
And I'm so upset with her. I'm just finding out about everything that's going on with her, you know, to try to push her to get her life together. So, if I could just get some guidance to what judges or whoever I need to speak with, so we could possibly get her in the court as soon as possible, so she can get out. She's a young mother. She has 3 kids at home.
I understand. Well, this is the thing. There's 3 different cases, and now that means that there's 3 different judges. Violations of probation. This is what you're going to have to do. Speak to the public defender's office, and she'll probably be represented by them if she can't afford an attorney. And she
did sign up this morning, Judge, and that's what I was explaining to her. Most likely there's going to be a PD assigned for all. These are different matters. They have a new law offense. I believe you have 2 VOPs in the CAPIA, so I told her most likely on Monday she'll be appointed an attorney to contact our office, find out who if those different attorneys are going to be, and set up some sort of earlier court date to address the bond issues, Judge.
Okay. All right. So in the meantime, ma'am, you are going to be held no bond on counts 3, 4, and 5, and you do have a driving while license is suspended $750 bond. Okay. Good luck to you, ma'am.
Love you, baby. Call me.
Hello. Okay, Roberto Antonio Palacios. Do you need this back? Okay, good morning. This is a municipal ordinance.
Yes,
We have
George.
Mr. Odom here.
Yes, George Odom on behalf of Mr. McLawrence. Judge, I am asking the court to get involved in the matter. It appears to be an issue that we can resolve this morning if the court is so willing to do so.
Okay, are you Roberto Antonio Palacios, sir? You have to hit the microphone. Thank you.
Yes, ma'am.
Okay, sir, you are charged with an open container in the city of Fort Lauderdale. Do you want to resolve your case today?
Yes, ma'am.
Okay, the court would adjudicate you and time serve you and impose a $78 court cost. How much time would
That's
you
fine.
need to pay that?
6 months, Judge, is fine.
I can't hear you, ma'am. It keeps going out.
Okay, can you hear me now?
Yes, yes.
Okay. The court would adjudicate you, time serve you, impose $78, which I have to, in court costs, and give you 6 months to pay. Is that something
That's
you'd
fine.
like to do? Okay, raise your right hand.
Yes.
Do you swear and/or affirm to tell the truth?
Yes, yes, Your Honor.
Okay, put your hand down. Are you Roberto Antonio Palacios, Palacios?
Yes,
Want to waive your right to a trial, sir?
yes.
Anybody forcing you to do this?
No,
Okay, you want to plead no contest to alcohol consumption violation in the city of Fort Lauderdale?
yes.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered, adjudicate, time served, $78 in court costs, 6 months to pay. You have 30 days to appeal the sentence of the court. Thank you, sir. Good luck. You're done with this case. Thank you.
Thank you.
Have a good day. Okay, next one is Shantilla Shawnee Stewart.
Yeah.
All right, Your Honor.
Okay, Shantilia Shawnee Stewart.
Yes.
Okay, ma'am, you have 4 out-of-state holds for felonies. You're gonna be held no bond. It's out of, it just says Floyd County. Anybody know where that is? Do you know where that is, ma'am?
It's Rome, Georgia.
Okay. All right, ma'am, you're gonna be held no bond. Good luck to you. Kimberly Allen.
I've been informed she bonded, Judge.
Shanika Lampkin.
North Broward.
Good morning, ma'am. You've been charged with retail theft. Are these for the public defender? You have my stamp?
We already represent Miss Lampkin, Judge, on her other 2 counts, one of which is a no bond hold for a violation of probation. Nevertheless, Miss Lampkin has asked me if the court would consider reducing her bond from $3,500 to $1,000 on count 3.
I'm sorry, to what?
$1,000.
Okay, any objection to probable cause?
No, Your Honor.
Okay, the court finds probable cause, ma'am, on the ad charge of retail theft between $300 or more than $300, second subsequent offense. State, any objection to $1,000 bond, no return to Publix?
Yes, Your Honor, I really don't see any reason to lower the bond. She's being held no bond because she was out on a punishable by life burglary with assault or battery on pretrial, and she violated her pretrial, so she's being held no bond on that.
When was that?
When was the burglary with battery, or when?
Pending?
I'm sorry?
It's pending?
Yes, she's being held no bond on that count.
When was she held no bond?
She was arrested February 27th on a resisting without violence, and then there was the active warrant was served on her.
Okay, I see. Okay, ma'am, you're not to return to the Publix at 1405 South Federal Highway, Pompano Beach, Florida, 33062. The court's gonna keep your bond at $3,500 due to your pending case. Good luck to you, ma'am. Jordan Croft.
North Broward.
Okay, are you Jordan Croft?
Yes.
Okay, ma'am, you're charged with 1 count possession of cocaine, possession of heroin, bond set at $1,000 each. Count 3 is drug paraphernalia possessed and/or used. Court does find probable cause. Can you afford the $2,100 in bond?
I haven't been able to make any phone calls Two-family, see it yet.
Okay.
1:30.
Spence?
Your Honor, Miss Croft is from Maryland. She was down here for for some treatment. Her family is not local. However, she does have a place to stay. She can stay at the Transformations Rehabilitation Center. From what I understand, her prior contact with the criminal justice system consists of misdemeanors. She has provided me with the name and number of her mother, who I'll call after court. She's not sure her mother's going to be able to come up with the bond as posted. I'd ask the court to consider placing her on pretrial release with random drug testing and allow her to go back to Transformations, which I understand from what she tells me they will take her back.
Your Honor, I don't have a problem pending verification if pretrial can, and I understand that's, you know, what Mr. Croft's representing Mr. Reedy, but I think if pretrial can confirm it, and it shouldn't be difficult, I think that would be better.
Don't talk about the facts of your case, ma'am.
September, there was a possession of a controlled substance. And it appears that Ms. Croft was arrested the 21st of this month, of last month, for possession of a controlled substance.
Okay, the court's gonna put her on pretrial release pending verification to, can I put a drug rehab facility? Well,
Transformations, Your Honor.
she can't get that one, then you're gonna have to change.
You have, she has some other ones in mind.
Right, so can we just put pending verification after we're able to verify whichever
All right,
case
then I'll
it is?
just put pending
Sure.
verification.
Thank you.
TAD monitor, no alcohol or intoxicants, random testing.
All right.
ROR on all three, thank you.
Pretrial release is going to verify which drug program you can go to, Jordan, and once they do, you can go there, okay? But it's up to you to keep track of your court dates and come back to court when you're supposed to.
What about, she has to check in?
And you have to check in. I explained that to her earlier. You're going to have to come downtown and check into
Saturday.
pretrial release.
Your Honor, so let me make sure I understand. It's pending verification, but she's going out with an electronic monitor, correct?
TAD.
Right,
Elmo.
that's an
Okay,
electronic monitor.
I didn't know if you just meant an Elmo. You know, like a GPS,
No,
just a TAD.
yes, Your Honor. So she's
They're different, correct?
pending verification.
An Elmo's different than a TAD, right?
They're both considered ELMO because the ELMO stands for electronic monitoring.
Okay,
One, the GPS is global positioning. The TAD is the transdermal alcohol detector.
correct, okay, that's what I want, thank you. Ma'am, you're gonna have to check in within 24 hours of being released. If it is on a weekend, you're responsible to report by, Monday, 3 p.m. They'll give you the address, it's right here by the courthouse or the jail where they release you. Okay, good luck to you, if you don't,
But
you'll
Your
be
Honor,
right back here.
if she does bond out, she won't be on pretrial or anything. She'll
No,
get
no, no.
posted bond.
I want it pending verification. That's the only way. She's ROR'd. I left the bonds in place. Isn't that what you told me to do?
Does the court want to go off for a minute?
No, you can say it.
If she's pending as long as they're going out on any kind of ankle monitor, she's gonna be verified.
That's
So
fine.
The court doesn't need to write pending verification. That's what
Okay.
threw me. So she's just going to be ROR with a TAD.
Yes.
Right, so we won't put pending verification now.
Okay, fine. Whatever it is, that's what you know what I want. Okay, thank you, ma'am. Emily Ellen Disla.
Also in North Broward.
Okay, Miss Disla. You have count 1 through 4, false owner info pond items, $300 or more, bond set at $10,000 each count. Then you have grand theft between $300 and $5,000, bond set at $10,000. And then you have dealing in stolen property, count 6 through 9, bond set at $10,000. You have a total of $90,000 in bond. Any objection to probable cause?
No, Your Honor.
Okay, the court finds probable cause on counts 1 through 9. State.
Your Honor, I want to advise the court, Ms. Disla has a pending, not in custody, capias that has not been served on her yet. Actually, we have her co-defendant on the docket. One moment. Rex Maldonado. It's a grand theft, aggregate value, and a common scheme involving a Kohl's on December 6th of last year. So, and I bring that up because it's just more of a pattern considering the allegations in the Warren affidavit. You know, and I understand obviously these are high bonds that Judge Orlando has set. She also has a DUI in Broward from 2013.
Judge, I do agree with the state that the bonds set by Judge Orlando are high. Ms. Disla is not going to be able to make those bonds. I don't know what the status of the not in custody capias is going to be or what her bond on those charges might be. But I do know that Ms. Disla is not going to be able to afford a $90,000 bond. She has been a resident of Florida for the last 26 years. She does have family here, including her mother. Her prior arrest record, I believe, consists of a DUI 5 years ago. She's been living in the same location for the last 10 years. She lives with her mother and her 8-year-old child. She's provided me with the number of her mother and her sister-in-law, who together could try and bond her out, but they're not going to be able to come up with $90,000. I'm pretty sure of that.
What it is you're asking for. How much?
I'm asking for pretrial release, Judge, with a monetary bond. If you could reduce counts 1 through 9 to $1,000 each for a total of $9,000 with pretrial release.
And Your Honor, I just wanted advice. I didn't see it first, but this is not Ms. Disla's first allegations involving theft. She had in Brevard County, 2010, grand theft, criminal mischief. In Broward, she had a theft in 2012 and another theft in 2012.
Were those convictions?
I've only had two.
Hold on, ma'am. Don't talk while you're ahead, okay?
Okay, Your Honor. Yeah, if they were petty thefts, if I don't say grand theft, I'm just letting you know for future reference. If I don't say grand theft, it's a misdemeanor.
Okay, perfect. Well, I do want to make the record clear, so
no, of course.
All right. So, anything further?
No.
No, Your Honor.
Okay, this is what the court's going to do. The court's going to do a $1,000 bond, count 1 through 9. What about no return to Macy's?
Your Honor, I would not only ask for no return to Macy's, I would ask that she not be allowed to enter any pawn shop in Broward County.
That's fine. You understand that, Emily?
Yes.
I'm just going to say not allowed to enter any pawn shop, whether it's Broward or wherever.
That's fine, Judge. Ms. Disla will not be going to any pawn shops.
That's the bottom line. Okay, so $1,000 bond. So I have 1, 2, 3, 4, 5, 6, 7, 8. Does your client work?
She was working doing government work for a government phone company until January. She indicated to me that she has spoken with her supervisor, and her supervisor wants her to come back to work.
Okay, court's going to do, this is what I'm going to do, $1,000 bond, total of $9,000. No return to Macy's, not allowed to enter any pawn shops at all whatsoever. I don't care where they're located, no entering any pawn shops. Count 3 is standard pretrial release, and you're going to have to report to pretrial release within 24 hours of you being released. So if you're released today, or they're not open tomorrow, they're open till 4 o'clock, but you have to get there by 3. So if not, you have to report by Monday. Do you understand?
Yes.
Okay, thank you very much. Good luck to you.
Good luck, Emily. I'll make some calls.
Thank you.
Tiffany Milburn.
Also North Broward.
All the count, no, number 3, I number them 1, 2, 3. Yes, 1 through 9. Good morning, are you Tiffany Milburn?
Yes, ma'am.
Ms. Milburn, you're charged with 1 count of grand theft between $300 and $5,000. The court does find probable cause, bond set at $1,000. Anybody wish to be heard?
Yes, Judge. Miss Milburn is down here to receive treatment for a substance abuse problem. She is staying at the Serenity Ranch. She believes they will take her back. I was going to call Serenity Ranch to confirm that. Her prior record, I think, from what she tells me, consists of a petty theft in 2015 that was dropped. There might be some other minor things in there. She has provided me with the number of her mother, who lives in Indiana, in the hopes of bonding her out. But if she is welcome back at Serenity Ranch and her record is what she says it is, I would ask the court to consider pretrial release for Miss Milburn.
Any objection?
I don't have an objection pending verification. I would note that she did have false information to law enforcement previously in the state of Indiana.
Okay, pretrial release pending verification. No return to target, ma'am, at 5800 South University Drive, Davie, Florida. Do you understand?
Yes, Your Honor.
Okay, you're also going to have to report to pretrial release within 24 hours of your release. I don't know if you heard me telling the other lady that just came. They close at 3 They close actually at 4 p.m., but you need to get there at 3. You need to fill out paperwork and register, so to speak. If you get out today or tomorrow, you have to report by Monday, okay?
Okay. Yes, Your Honor.
3 p.m. the latest. Thank you.
Thank you.
Pardon, ROR. Okay, pending verification then.
Yeah, it's a Serenity Ranch. Do you want me to try and get that number pretrial, or do you have it?
Okay, Shantavia Shepherd.
Ms. Shepherd is here present at main, Judge.
Okay. Okay, Ms. Shepherd, you are charged with 1 count, possession of cannabis, 20 grams or less. Count 2, driving while license is suspended. 3rd or subsequent offense. Bond set at $750, and actually on the possession of cannabis, there's no bond attached to that, so that's basically an ROR. Also the same for count 3, failure to register a vehicle. You do have 2 capious misdemeanors. You are set to go before Division MS, which is on March 16, 2018 at 8 a.m. Anybody want to be heard with regard to bond on count 2? She failed to appear, by the way.
Judge, in speaking with Ms. Shepherd, she did advise me that her family will be posting her bond.
Okay, great. Thank you very much. Good luck. Ma'am, you still have to go to court on 3/16, 2018. It's the 5th floor. I don't know who the judge is. It's a rotating division with judges. Thank you. 10 a.m.
Let me write that down for her, Judge, because let me get a sheet. Hold on 1 second.
Thank you.
It's March 16th, Judge? Do you know what?
March 16th.
At 8 a.m., correct? On the
No, 10 a.m.
10 a.m.?
Courtroom 5155.
5155, thank you.
You're welcome. Okay, do we have Brittany Miller? Brittany Miller, and then we have Clyde Lewis.
Miss Miller is in North Broward, Judge.
Okay. All right, Brittany Miller.
I think I passed it through.
Yes, ma'am.
Considering count 2's in the ball.
Okay, Ms. Miller, you have 1 count of possession of fentanyl, $1,000 bond, then you have a warrant for a VOP pretrial misdemeanor, which you are being held, no bond. Court does find probable cause. What's going on over there?
Phone fell off the table.
No, I know, teasing you.
They're always causing trouble, Judge.
I know. Okay, warrant and revocation for violation of pretrial services signed by Judge Pohl, no bond. So we'll leave the $1,000 bond in place unless you want to address it, sir.
Judge, would it be possible to resolve the violation of probation no bond hold at this time?
No.
Violation of
All right,
pretrial.
Tiffany, Brittany, you're going to have to wait and go in front of your judge, okay?
Do you know when that court date is?
I don't have a court date for you yet, but it should be soon.
Okay, apply for the public defender, ma'am. in the jail if you haven't done so already.
So I have to go in front of 2 different judges?
2 different judges, ma'am. Okay, good luck to you.
Thank you.
You're welcome. Floyd Lewis, and then we have Angel Rivera.
Mr. Lewis is here present, Judge of Maine.
Okay, Mr. Lewis, you have a violation of probation for a misdemeanor. You're going before Judge Cal Evans on March 7th at 9 a.m. You're going to be held, or I'm sorry, you have a $500 bond. If you bond out, you still have to go to the hearing on March 7th, Judge Evans, at 9 a.m., sir. Good luck to you. Next one is Angel Rivera and then Harold Clayson.
Mr. Rivera is here present, Judge of Maine.
Okay.
I don't know who this one is.
Okay, sir, you have a capias. You no-showed a calendar call for a petty theft.
Judge, my understanding is this is a 2015 case. I believe it was out of a Walmart. Merchandise was recovered, so there's no outstanding restitution issues. And speaking, Mr. Rivera, he wished to ask the court if you would consider resolving his case today for time served.
Really, who are the people that walk out the courtroom with dockets in their hand?
I can't see him.
I don't know who was there. Who was he? Oh, okay, but he's leaving with the docket? Is there one up there? I mean, I don't know if, I don't have a problem, but I've never seen him before, so, okay. Okay, State.
State's offered via adjudication time served.
Adjudication time served.
He wishes to accept the state's
Did you,
offer, Judge.
did you talk to him that if he gets another one, or the ramifications, if he has 2, he can get a felony?
I will. Judge, this speaks on. We're ready to proceed.
Okay, raise your right hand, sir. Do you swear and or affirm to tell the truth?
Yes.
Your name Angel Rivera, R-I-V-E-R-A?
Angel Martin Rivera, ma'am.
Okay, put your
Yes.
hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes.
Anybody forcing you to do this?
No.
Okay, you understand that if you plead of his charge and you get another one, it might be considered a felony even though it's a petty theft or
Yes,
retail
ma'am.
theft? Okay. Ever been treated for a mental illness?
Yes.
Okay, does your mental illness, don't tell me what it is, affect your ability to understand the nature of the proceedings here today with clarity?
No, ma'am.
Okay, you understand that if you're not a U.S. citizen, a plea of his charge could result in deportation proceedings and affect your ability to remain in the United States?
Yes, ma'am.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. You're pleading no contest to petty theft, sir?
Yes, ma'am.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you, time serve you, impose court costs, which I have to by law, of $293. So it's adjudicate, time served, $293. How much time to pay?
6 months, Judge.
Okay, the court will give you 6 months to pay the $293. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Harold Clayson and then Cody Coker.
Mr. Clayson is in North Broward, Judge, and he may be interested in a resolution of this matter this morning.
Okay. State, operating without a valid license. Good morning, Mr. Clayson. How are you?
Good morning.
Okay.
Blessed. Thank you for asking.
Okay. Sir, you have a capias misdemeanor. You did not, appears, I don't know. Okay, anyway, in any event, sir, you have operating without a valid license at bond set at $1,000. Do you want to resolve your case today, sir?
That would be nice, thank you.
Okay, are you trying to resolve your case because you can't afford the $1,000 bond?
Correct.
Okay, then I can't accept his plea if it's just because of $1,000.
Is the only reason you're taking the plea because you can't bond out, or do you want to resolve it today?
I'd just rather resolve it.
Okay, are you sure?
Correct.
Okay, state.
One moment, Judge. Does he have no prior withholds? Any prior traffic stuff like that somewhere
He has
else?
burglary of a dwelling. There are 88 cases.
No, I understand, Your Honor. I'm just trying to, I need to make sure of one thing first. Just keep it going. You can go faster.
Okay, while you're figuring that out, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Harold Clayson, C-L-A-S-O-N?
Correct, ma'am.
It's my understanding you wish to waive your right to a trial, sir?
Correct, thank you.
Anybody forcing you to do this?
No, ma'am.
Under the influence of any drugs, alcohol, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States, sir?
No, ma'am.
Okay. Do you understand that if you're not a U.S. citizen and you plead no contest or guilty to this charge, you are subject possibly to deportation? Do you understand that?
Yes, I understand that.
Okay.
Sorry about that.
That's okay. I understand.
Looks like this would be a first set off from a withhold court cost judicial notice time served.
Okay, sir. So the state is offering, and the court would be willing to impose a sentence if you want to plead no contest to a withhold of adjudication, which means no conviction, and court cost of $293. The court will give you up to 1 year to pay that. The $293. You do need to get a valid driver's license. Is that what you want to do, sir? Plead no
Yes,
contest to no
I've also-
operating. Hold on. You want to plead no contest to operating without a valid driver's license, sir?
Correct.
Yes?
Yes.
Okay, go ahead, sir.
I was wanting to say I've been incarcerated. I got the ticket on the 13th of December. I've been incarcerated since the 14th of December. I haven't been released since then. So I have over almost 90 days in on this.
Okay, well, the court's still gonna give you a withhold of adjudication and court costs. Regardless of how much time you served in jail, the court still has to impose court costs, even if you were in jail for up to 60 days or 1 year. Okay?
Okay, that's not-
So I'll give you 293, withhold court costs, $293, 1 year to pay, and the court takes judicial notice of your time in the Broward County Jail. You have 30 days to appeal the sentence of the court. You're done with this case, sir. Thank you.
You all have a blessed day. Thank you.
You too.
You too, Mr. Clayson. Your Honor, our Spanish interpreter is present.
Okay. Who do we have that needs a Spanish interpreter?
Judge, no, have a seat, sir. On page 20, Mr. Carlos
What page are we
Sanchez.
on now? 8. Sanchez. Carlos Sanchez?
Yes, Carlos Sanchez on page 20, Judge.
Your Honor, if we, Your Honor, I'm gonna add.
Let me just find it. Hold on.
Okay.
Just give me.
On page 20, so it's going to be probably toward the end of your document, the total number is 23, Judge.
Thank you. Okay, State, go ahead.
Your Honor, I was emailed today by private attorney Jeffrey Bloom. He advised me he hadn't determined yet if he is going to be he asked if he could be put on recall because he hasn't determined if he's going to be representing Mr. Sanchez Ramirez at this point.
De parte del
That's up to Mr.
Estado,
Ramirez to determine. No, I'm just saying it's up to him.
Well, it's also up to
Sanchez,
Mr. Bloom
right now, I'm
also.
speaking to him, he believes maybe that his wife hired him, but he wasn't 100% sure, Judge.
It's also Mr. Bloom's call also. He chooses if he's going to represent someone or not.
No, I understand, but it's ultimately up to the defendant as well. So, sir, I've been told that your wife is trying to engage the services of this attorney. Is that correct, Mr. Linder?
señor, me han contado que su esposa está tratando de contratar a un abogado. ¿Es correcto, señor?
Or there's conversations going on?
Yes.
I don't know who called Mr. Bloom. I just know Mr. Bloom told me it's it's not 100% yet. He may be representing him, and he asked if I could put the case on recall.
De parte del Estado están avisando que el abogado Jeffrey Bloom se ha comunicado con el Estado, dice que no está seguro todavía si está representando al señor, pero pedía que se le diera más tiempo para decidir y para volver a ver el caso más tarde, hoy.
Okay, so my question is, put it on recall till when? How long is it gonna take them to determine?
Can you email him, Judge? I don't know.
All right,
Entonces,
so we'll just put this case briefly on recall.
de parte de la señoría pregunta a ver cuánto tiempo van a necesitar. Lo que van a hacer es esperar un ratito para ver si se pueden comunicar con el abogado.
Ms. Linder, I'm just trying to ascertain, how long this is gonna be for. I mean, it can't be something.
I understand, Your Honor, but you're asking me, and I.
No,
I really
I'm just
don't
telling
know.
you why I'm asking the question. I'm just trying to ascertain how long. I mean. All right, Madam Interpreter, raise your right hand. Do you swear and/or affirm to translate from Spanish to English, English to Spanish?
I do. Good morning, Your Honor.
Hi.
Hi. Solange Sands, Saenz.
Okay. And Ms. Solange, did you interpret everything from Spanish to English, English to Spanish with this gentleman, Mr. Carlos Sanchez Romero, that we just had from Spanish to English, English to Spanish to the best of your ability?
I did, Your Honor.
Okay, thank you.
You're
Do
welcome.
we have anybody else, Mr. Romero, that we need the Spanish?
Not here at Maine, Judge.
Okay, let's do a call. If you could make an announcement.
I'll be happy to, Your Honor. Si alguien más necesita los servicios del intérprete, por favor avisar a la persona que está a cargo.
Okay, anybody at North Broward?
North Broward's good, Your Honor.
Thank you. Conti? No? Okay, Paul Ryan.
All right, good, Your Honor.
Okay, thank you so much.
You're very welcome,
Can you
Your
just have
Honor.
a seat for one moment? Mr. Linder did email the attorney, and hopefully we'll be able to find out, okay?
I'll be happy to, Your Honor.
All
Thank
right,
you.
thank you. Cody Coker.
He's a North Broward judge. This is a municipal ordinance.
Okay. Okay, Mr. Coker,
Yes, ma'am.
you are charged with no lodging on city-owned property.
Yes, ma'am.
Want to resolve your case today?
Yes, ma'am.
You promise not to return back to that property?
Yes, ma'am.
You realize you didn't show up for arraignment, sir?
No, ma'am.
Okay. All right,
did
raise
not,
your
ma'am.
right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, your name's Cody Coker.
Yes, ma'am.
Want to resolve your case today? You can put your hand down for an adjudication in time served and no return to that property.
Yes, ma'am.
Gonna give up your right to a trial, sir?
Yes, ma'am.
No one's forcing you to do this, and you're not on the under the influence of any drugs, alcohol, or medication?
No, ma'am.
Okay, the court want to plead no contest to lodging on city-owned property, correct, sir?
Yes, ma'am.
Okay, court's gonna adjudicate your time, serve you, accept your plea, $78, which I have to impose in court costs, and the court will give you 6 months to pay that, no return, sir. You understand?
Yes, ma'am.
All right, don't come back again, sir, okay?
Yes, ma'am.
Mr. Bloom got back to me.
Okay, good. All right. Okay, let's just go back, wait one moment, sir. Let's go back to Carlos Edua Sanchez Romero. Madam Interpreter?
Senor Sanchez, ven por favor.
All right.
Bien.
Your Honor, Mr. Bloom advised he is going to be representing Mr. Sanchez Romero and asked that the case be reset for the PM docket.
No problem. We'll reset it for the PM docket today. Thank you.
De parte del Estado avisan que el señor Bloom, el abogado, ha dicho que sí va a representar al señor Sánchez Romero. Entonces pidió que este caso se vuelva a presentar en la tarde, el calendario de la tarde. Así que nos vemos en la tarde, ¿ok? Suerte, señor. Okay.
Thank you, sir, and thank you so much.
You're welcome, Your
Have
Honor.
a great weekend. Bye-bye.
Thank you so much.
Okay,
You too.
so we'll reset this to this afternoon. All right, Alfred Mitchell.
Yes, ma'am. No problem, Your Honor.
Okay. Sir, you are charged resisting an officer without violence. Any objection to probable cause?
No, ma'am.
No, Your Honor, I think Mr. Mitchell might be interested in resolving the case today, if
Okay.
possible.
Okay, state.
Okay. I can just reset. I'm just checking, Your Honor, to see if he has anything out of county.
One of the things he's gonna have to do is agree not to go back to the Seminole Casino.
Do you understand that, Mr. Mitchell?
Yes, sir.
If we resolve your case here this morning, you can't go back there. You'll just get arrested again. Okay?
And state's offered to be time served, Judge.
Okay, adjudication and time served.
Yes, ma'am.
Would you like an adjudication and time served to resolve your case today, Mr. Mitchell?
Yes.
Time to pay the $293 in court costs.
6 months, Judge.
You wanna ask him? Maybe once-
Can you pay that? Can you pay the court costs within 6 months?
Or do you need more time?
I don't have no money. I don't work. I don't got nothing.
I guess a year then, Judge.
I'll give it a year. All right, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yeah.
Yes?
Yes.
Okay, what's your name? Alfred Mitchell?
Yes.
Mitchell, and put your hand down. Is that your name?
Yes, ma'am.
It's my understanding you wish to waive your right to a trial?
That's right.
You're gonna give up your right to a trial, sir? Yes?
What's the trial?
Okay, Mr. Reedy.
Mr. Mitchell, you have a right to be tried by a jury or your peers. At that trial, the state would have to prove your guilt beyond a reasonable doubt. You have a right to call witnesses on your own behalf, testify on your own behalf. You have a right to a lawyer to represent you at that trial. If the jury is not convinced that you're guilty beyond a reasonable doubt, they'll find you not guilty. If they are convinced that you are guilty beyond a reasonable doubt, they could find you guilty. Meanwhile, you can either post a $100 bond. Mr. Mitchell, are you listening to me?
$100? All right. That's it, sir. I'm finished.
All right. I guess today, Judge, I would ask you to leave the $100 bond in place.
Okay,
Run transfer?
thank
Brian.
you. Alex Sangster?
Brian, run transfer.
Thank you
Yeah,
for
I'm
your
gonna
efforts.
flag it.
Medical reset for Mr. Sangster?
Stalking, about 9 years ago, stalking at a date like 9 years ago. They'll figure it out a later
Pablo
date.
Roca?
All right.
Mr. Pablo Rocha is here present at Main Judge. I believe these are municipal ordinance cases.
Okay, you have an out-of-county hold for a misdemeanor, sir. For trespassing. $20,000 bond has been set. It's out of, I believe it's Miami-Dade. All right, sir, so you have 2 capious misdemeanor charges. You failed to appear for court. You have 2 open containers and you have 1 trespass. Does anybody know where that's originating out of? Is that a misdemeanor or a felony? Okay. All right, sir, you want to resolve your 2 cases today, the open container, however, you're going to be held on the trespass on $20,000 and be transferred to Dade County. What would you like to do?
I would like to resolve the open containers.
Okay, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
Your name is Pablo Roca,
Yes.
R-O-C-H-A. Put your hand down. Yes?
Yes.
Okay, it's my understanding you wish to waive your right to an attorney in trial in the 2 open container cases.
Yes, ma'am.
Anybody forcing you to do this?
No.
Okay, the court's gonna withhold, you wanna plead no contest?
Yes, ma'am.
Okay, court's gonna withhold and impose court costs. Two separate cases, $78. In each case, the court will give you the 6 months to pay for $78 in count 1 and 2. And the court will take judicial notice of the time that you served in jail.
Okay, thank you.
You're welcome. Good luck to you. You have 30 days to appeal the sentence of the court. Can't afford an attorney, one will be appointed. Good luck, sir. Okay, Michael Allen Downey and then Sean Ferguson.
Judge, before, it's funny, today, I think maybe there's a wire that's loose. Every now and then, your voice chip goes mute. It's like you're saying a sentence and one word will disappear. It's weird.
Okay.
Just
Well,
wanted to let you know.
I can
that's
have,
what I've
well, let me know if you don't hear me. I want to make sure you hear everything. Have you been able to hear everything I'm saying?
Yes,
Okay.
but it goes in and out certain times.
Wonder if anybody else, hold on. Can I have a deputy at North Broward? Now I'm gonna call Conti and Paul Ryan. Have you been having a problem hearing my voice? Has it been fading in and out? It's okay? Thank you. Conti, has my voice been fading in and out?
Absolutely not.
All right, thank you. Paul Ryan.
No, ma'am, coming in.
Okay, thank you very much. All right, call Craig, tell him the main jail. They allege that my voice is coming in and out, fading in and out, okay? But it's not happening at Paul Ryan, Conti, or North Broward. Thank you. Thank you. If you can't hear me at any time, Mr. Romero, let me know. Michael Allen Downey, and then Sean Ferguson. Okay, sir, you have one count of false ID given to a Leo. There's, with no bond attached to that, resisting an officer without violence, $100 bond. Trespass, failure to leave property upon order by owner, there's no bond attached to that. Any objection to probable cause?
No, Your Honor.
Okay, the court finds probable cause. Can you afford the $100 bond, sir?
Judge, in speaking with Mr. Downey, unfortunately, he just got laid off from work. He worked at the Days Inn, and now he's currently looking for work. He's going to Broward College, studying criminology. He's a freshman. He's there on the GI Bill. He's a United States Marine. He was from 2010 to 2014. Judge, he's living in Hollywood, roommates.
Okay, so you're asking for ROR?
ROR, correct.
Any objection to ROR?
No.
Okay, ROR. Thank you, sir. Make sure he shows up for his court date, okay? Sean Ferguson. And then next one is Manuel Cabasa Marrera.
Page 10. Come on up, Mr. Ferguson. Good morning, Judge.
Good morning. Let's see.
Exactly. What happened to this guy?
Okay, you have a capious misdemeanor for driving while license is suspended.
My license is not suspended.
That's what it says, driving while license is suspended. $2,000 bond has been set by Judge Carpenter Toy.
She's on the wrong thing.
No show at arraignment.
She's coming up there.
Thank you. Manuel Cabasa Marrero, and then Christopher Ramon Ramos. Hello? Hi.
Yeah, if I really let it grow.
Okay, tell him I'm just gonna do one more person, and then we'll take a break. How long? Okay, I'm being told by Craig that we're gonna have to take a break. Is the voice still going, or no?
No, but like I said, it cuts out at certain times. It's like not noticeable, like a word.
If it's not noticeable.
Okay, he said it's not noticeable. Okay, so, hold on. Okay, Manuel Cabasa Marrero.
No, this is Sean Ferguson, Judge.
Yes, the entire case we just handled.
Okay, he has a capias for 2,000, no show at arraignment.
Judge, he wishes to ask the court if you would consider resolving this case today for time served. This is a 2001 capias, Judge.
Any objection to a withholding court cost since it's a 2001?
I'm probably not, Your Honor. I'm just checking his driving record.
Okay.
There is something. Yeah, you tell me. Yeah, it's all right. Your Honor,
Can I
I'm
take
fine.
this top one off? Okay.
I'm fine with it as long as he's advised that, 3 within 5.
Okay. 3 within 5. You talked to him?
Yes, Judge.
Okay, sir. Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, sir. It's my understanding you wish to waive your right to a trial.
Yes.
Your name is Sean Ferguson, Ferguson.
Yes.
Okay, listen to my question. Is anybody forcing you to do this?
No.
Are you under the influence of any drugs, alcohol, or medication, or ever been treated for a mental illness?
No.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability, sir, to remain in the United States? You understand that? Okay. You understand that if you get 3 convictions within 5 years of driving while license is suspended, the driver's license bureau is going to suspend your license for 5 years as a habitual offender. Do you understand that?
Okay.
So that's 3 convictions within 5 years. You understand?
Yes.
All right. Understanding what I just explained to you, you're pleading guilty or no contest to driving while license is suspended.
No contest.
Okay. The court's going to withhold adjudication. Impose court costs, which I'm required to do, of $293. Time to pay?
1 year, Judge.
Court will give you 1 year to pay. And the court will take judicial notice, sir, of the time that you served in the Broward County Jail. Good luck to you, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Manuel Cabasa Marrero.
Mr. Cabeza, come on up. Good morning, Judge.
Okay, sir, your bond has been posted. Thank you very much. Christopher Ramon Ramos, and then Angelo Christopher Dovato.
Come on up, sir.
Okay, his bond has been posted.
You're going home. Mr. Dovato?
Angelo Christopher Dovato, and then David McDougall.
Mr. Dovato's here present, Judge.
Okay, Mr. Dovato, you have driving while license is suspended, first offense. Court does capias, $250 bond. He has to go to court March 12, 2018 at 2 p.m.
Judge, in speaking Mr. Dovato, he wishes to ask the court you would consider resolving this case today.
Sure. State.
One moment. It appears this will habitualize him. I have no offer.
This is going to habitualize him.
And just so the court's aware, he resolved 2 DWLSs last month, 1 in Broward, 1 in Miami-Dade.
Judge, I know the court's concerned. Judge, normally I wouldn't ask on a capias. It's a $250 bond. We had $200 in property, but as you know, when they come in here, they already take some off the top as far as expenses. Would you consider just reducing from 250 to 200, so hopefully he has enough in property to bond out?
Sure.
Thank you, Judge. Would you sign an order so he can have access to his property?
Yes.
Thank you, Judge.
You're welcome. Okay. David McDougall.
No problem, Judge.
And then we have Demetrius Brown.
McDougall's a medical research, Your Honor.
Okay.
Your Honor,
Thank you, hold on.
Your Honor, it looks like this has been reset a couple days. I just asked if the court can make a PC determination.
Okay, defense,
Reread the PC sheet. That's fine, Judge.
for touch or strike battery and trespass, failure to leave by order, upon order by owner.
Yes, Your Honor.
Okay, and the public defender waives his appearance.
Yes, Judge, but we would like him brought back to address the issues of bond.
Okay, I'm gonna write that on the paper. We have Demetris Brown. Thank you. Okay. All right, Demetris Brown. Good morning, sir. You have a capious felony. You're going before your judge, Judge Paul Backman, on March 5th, 2018 at 8 a.m., and we need to discuss bond. This is an ad charge
Yes, ma'am.
for felony murder in the second degree.
Yes, ma'am.
I need to write that in here. It says capious felony.
Oh, it doesn't say the charge?
Nope, it just says capious felony.
Can't hurt.
Okay, so it's felony murder in the second degree.
Yes.
Okay, go ahead.
Thank you, Your Honor. I provided Your Honor and defense counsel with a copy of the
Warrant.
original arrest warrant. Your Honor, what happened was an information was first filed for armed burglary based on the same set and circumstances, and he's currently being held no bond on that. After that information was filed, the state filed an amended information, ad charging felony murder in the second degree. That is now before the court. He's also, well, Your Honor, the state would be asking, based on the allegations in the arrest warrant affidavit, finding a proof evident or presumption grade, seeking a no bond hold for first appearance purposes only.
Okay. Defense?
In light of the fact that Mr. Brown has a no bond hold on count one and a no bond hold from a marshal's office hold, we would defer any argument regarding proof evident presumption grade until Mr. Brown can appear in front of his division judge.
Okay, Mr. Demetris Brown, is that your name, sir?
Yes, ma'am.
Okay, sir, I have reviewed the probable cause affidavit, or actually the warrant to arrest filed in your case, and the court does find probable cause. I further find the proof of guilt to be evident or the presumption great. You're going to be held without bond pending further order of the court. This order is without prejudice for you to file a motion before your assigned division judge and request a hearing under State v. Arthur. So you're going to be held no bond, sir, on the felony murder in the second degree. Good luck to you, sir.
Your Honor, the North Broward Detention Center has asked if you could take a case out of turn.
Sure.
It's the next to last case on your docket, Jack Voltaire.
Don't worry. This is going to be real quick.
Okay, Jack Voltaire.
Hello there, Your Honor. How you doing?
Good. Where is he?
North Broward.
Hello, sir. How are you?
I'm doing good. How you doing, Your Honor?
Fine, thank you. Are you Jack Voltaire?
Yes, Your Honor.
All right, sir. You're charged of count one, burglary, unoccupied conveyance, unarmed. We need to talk about bond. You do have 2 capious felonies where you are being held no bond. I know that we found PC for attempted burglary of a conveyance unarmed. It doesn't say that here, so let me write that in. Attempted burglary, conveyance unarmed. Okay, State.
Your Honor, because Mr. Voltaire had a pending felony when he allegedly committed this attempted burglary, I'm gonna be requesting a $2,500 bond on count one.
So is pre-trial available or what?
Not on this charge, sir, not on attempted burglary of a conveyance unarmed, no. So, defense?
Your Honor, Mr. Voltaire also has 2 no bond holds, so he's going to have to go in front of his division judge no matter what. If the court wants to set a $2,500 bond, that's fine. He's going to have to resolve that along with his other matters at another location at another time.
Okay, sir, so there's no victim contact, direct or indirect, with the alleged victim with the initials JPRE. That means no contact through third party, social media, in person, calling, texting, liking anything, any social media. As far as count one, attempted burglary of a conveyance, unarmed, bond set at $2,500. Counts 2 and 3, the capious felonies, are no bond holds. Thank you. Good luck to you.
So how many charges am I facing?
Right now, I have 3 here today, but I don't know if there's other ones. So
Is that old
contact.
charges? I mean, I'm confused. Is that old charges, new charges? Like, because I swear I did time served. Like, I don't know what's going on, man. Are those charges new, old charges? Like, because I swear I was out. And I thought I did time served.
Okay, sir, what the best thing for you to do is find out about all charges pending. I don't know what you have and how many divisions or how it's split up, so you just need to contact your public defender. Can we have his public defender maybe reach out to him and go over it with him? He does have a right to know the charges.
Well, we're really just appointed today, so it'll take a couple of days for the case to be assigned. But somebody will be up to see you, Mr. Voltaire, because I'm going to be flagging your case to send someone to see you, so.
All right,
Y'all said that last time I had to speak to a public.
Yes, well, now it's the next time.
Shortly, sir. Thank you. All right, next one is Raymond Wiles. I'm sorry, where? Conti, okay. All right, Mr. Wiles, you have a, thank you, capious felony. State just handed me something. Did the defense, did you get this also?
I provided the court, yes, it's a copy of a report for Mr. Wiles.
The narrative from the officer. All right, sir, you have an ad charge, burglary with assault/battery. This is going to be before Judge Fine. Let's talk about bond.
Yeah, Your Honor, this is a PBL. Mr. Wiles is being held on count one for carjacking with a $5,000 bond. He's also being held no bond on count two on a grand theft auto. Your Honor, based on the allegations, the state would be seeking a finding of proof evident or presumption great. The allegation being Mr. Wiles unlawfully entered the victim's car to rob him of his car. The battery occurred when the alleged victim tried to remove Mr. Wiles from his vehicle, reaching in, and was unable to.
Your Honor, based on Mr. Wiles' other pending no bond holds, we would defer any argument regarding proof evident presumption great until Mr. Wiles can appear in front of his division judge, and we actually represent him currently on a couple of cases, and I'm trying to find out his court date, if my computer would not be so slow. His arraignment, I believe, is next week, early next week.
All right. All right, sir, I have reviewed the probable cause affidavit and the other paperwork filed in your case, and I find probable cause. I further find the proof of guilt to be evident or the presumption great. Therefore, you're going to be held without bond pending further order of the court. This order is without prejudice, sir, for you to file a motion to set bond with your assigned division judge and request a hearing under State v. Arthur. You're going to be held no bond on this third charge, sir. Thank you and good luck to you, okay? And if you could attach this, thank you. Lionel Bain.
Copy.
Okay, Mr. Bain, you have a capious felony, $1,000 bond's been set. It says Judge Bailey, but it says Sarasota County hold.
It's both.
Okay. All right, so this is 15. I don't know why I have counts 1, 2, 3, 4, and 5 here, but
Those,
this is a capious felony for grand theft in the third degree.
the grand theft's an ad charge. The other counts 1, 2, and 5 are change of charges.
So we're gonna add count 4, grand theft in the third degree, which actually says 15 capious felony on mine, by the way. And the change of charges are
Okay.
1, 2, and 5, yeah. All right, so the only thing on the docket for today, sir, is there's an ad charge, which is grand theft in the third degree. Bond is set at $1,000. And you have a hold for Sarasota County. You're going before your division judge on Monday, March 5th at 8:30 a.m. for this grand theft in the third degree. Thank you, sir.
Okay, I got court date on the 6th, Tuesday.
Okay, you also have one on Monday.
Okay.
Okay?
Thank you.
Thank you. Sean Kazeen Walton.
Yes, ma'am, Your Honor.
Okay, where are you, sir? Okay, Mr. Walton. Good morning, sir. You have petty theft. These are ad charges of a second degree, first offense. No bond attached, criminal mischief over $1,000, $500 bond has been attached to that. Any objection to probable cause? Any objection to probable cause on this one?
No, Your Honor.
This is Sean Walton. Okay, court finds probable cause on counts 7 and 8. Can you pay the $500 bond, sir?
No, ma'am.
Okay, is he being held on
He's
something
got a
else?
parole hold. He's got, I believe, other.
All right, sir, you have a bunch of other holds. So this is what the court will do. The court will ROR you on count 8.
Yes, ma'am.
Thank you.
Thank you.
Is he alive still? No, I'm sorry. No, Your Honor. It was nothing.
I
it
don't
was
care.
leaking something.
Howard Matthew Adler.
Mr. Adler's here present, Judge, I mean?
Okay, you have an ad charge, I believe, of grand theft between $300 and $5,000. Bond, it's an ad charge. Bond has been set at $1,000. Court does find probable cause. Anybody want to be heard with regard to the $1,000?
Your Honor, you may recall Mr. Adler. He appeared before the court
Yesterday or the day, this is the rent?
either Wednesday or Thursday.
I remember.
Exactly the same allegations as this grand theft. He kept his bonds in place on those cases. I'm just asking the court to do the same as well.
Mr. Adler's total bond is $2,850 on counts 1 through 4.
How much?
$2,850.
So it's $1,000 each, right?
Pretty much.
Okay, sir, you're to have no contact, direct or indirect, with the alleged victim in this case, whose initials are S.E., who is Sean Adler, has the same last name as you, and that means no contact through third parties, social media, on the phone, in person, texting, blogging, liking anything on social media, and the like. Court's going to keep the bond at $1,000. Thank you, sir. Good luck to you.
Thank you.
Donald Alistall Raming.
Mr. Reed, come on up, please.
Okay, Mr. Raming, you have count 1, possession of cocaine, $1,000 bond. Then you have count 2, possession of cannabis under 20 grams. Court's going to ROR you on that. Anybody want to be heard with regard to the possession of cocaine?
Judge, at this time, Mr. Raming did advise me that his friend is going to be posting his bond, so at this time, nothing more is added.
Okay, court finds probable cause, 1,000 on 1, ROR on the possession of marijuana. Next one is going to be Jason Christopher Arthur. And then
Mr. Arthur,
we
come on
have
up, please.
Sebastian Kenrick Blucher. Okay, Mr. Arthur, you're charged of count 1, aggravated assault with a deadly weapon. Okay, thank you. Without intent to kill. We have to talk about bond, and we also have to talk about a bond on possession of a weapon or ammo by a convicted U.S. felon. Any objection to probable cause?
Based on Mr. Arthur's statements, no, Your Honor.
Okay, the court's going to find probable cause. The court is going to order no contact, direct or indirect, with the alleged victim in this case, who has the initials of CJ. First name is Carmise. Sir, that means, if you heard me telling other people, that means no contact in person, phone, third party, social media, texting, blogging, liking anything with the alleged victim with the initials CJ. State?
Your Honor, the state is going to be requesting $15,000 bond on count one, $10,000 bond on count two, noting act of violence with a firearm in this matter, the strength of the evidence, both there's victim and witness, victim's coworker to the incident, plus, as Mr. Reedy mentioned, Mr. Arthur's post-Miranda statement. Also noting in the PC his priors, he has prior felonies out of other states, so he's not even supposed to be in possession of a firearm legally to begin with. Showing, one moment, Your Honor. Since, what state was this? Okay, out of the state of Arkansas, 2001 commercial burglary, theft of property, fleeing and eluding. He was sentenced to 6 years in state prison. 2002 felony robbery, theft of property, sentenced to 7 years.
So the last contact was 2001?
Last contact was 2001, but he was sentenced to 7 years in state prison.
No,
So
I
that-
understand, I'm just verifying that.
I understand, Your Honor.
Okay, defense?
Judge, in suing Mr. Arthur, he's 36 years old. He's been now living in our community for the past 3 years. Basically, he's, as Your Honor pointed out, it's been a while since he had any sort of contact with the system. Judge, he's working. He's working for a company called Local 500. He's a stagehand. He works in stage and theater, so depending on the clients they get, he can get up to about $500 a week. He's been doing that now steadily for 1 year. He's living in Oakland Park, been residing in the same apartment for 2 years now. His rent is $950. He shares that with his girlfriend. His girlfriend is an aspiring model, so right now she has a steady job or anything like that. From what he advised me, I think last time she got paid $500. The reason why I'm bringing that up, as you can see, their financial resources are very, very limited. From what the state suggested, $15,000 on one, $10,000 on the other, $25,000 is something that he cannot come up with. Judge, I'd ask you to consider releasing Mr. Arthur on a $1,500 bond on count one, $1,000 bond on count two. And Judge, I do understand your Honor's concern. We would not object to standard pretrial with Mr. Arthur.
Standard pretrial when he pointed a gun at someone?
Judge, if you feel more comfortable with level two, Judge. But that's the defense's position.
Court's gonna set bond at $5,000 per count. Court's gonna order no victim contact, direct or indirect, as I said before, with the alleged victim with the initial CJ, GPS level 2. And he is to maintain 1,000 feet from the alleged victim's address of 2530 Northwest 27th Street. Okay, thank you very much. Good
And-
luck to you, sir.
Your Honor, we'd ask no firearms, ammunition.
Okay, another condition, sir, no firearms, ammunitions, or weapons.
Yes, Judge.
Okay, next one's gonna be Sebastian Kendrick Blucher.
Mr. Blucher is here present, Judge. I may need to decline the service of public defender.
Okay, Mr. Blucher, you're charged with count 1, possession of burglary tools with the intent to use. Bond's been set at $1,000. Loitering or prowling, possession of cannabis under 20 grams. Court's going to ROR you on those. And then disobey a stop sign. That's not for magistrate court. That's actually a civil traffic infraction. But you do have a probation violation or a violation of community control. It doesn't tell me which one, but it's one of the two. You're going to be held no bond on that, which is count 5. So what are we doing with, can you afford, first of all, any objection to probable cause? Court does find probable cause. State, what are you recommending as to 1?
Considering, one moment. There's a bond set on that, right? Considering his no bond holds, I'm not asking for any modification.
Okay, can you afford the $1,000 bond, sir? If you resolve your no bond case?
A bond?
You have a no bond hold, sir, so this is what I'm gonna do. I'm gonna keep your bond at $1,000 because you have the no bond hold. You can go, that's without prejudice, to go before your division judge. Do you have an attorney? Is that how you're doing it? Since bond is... Sign with the X's, this is simple. Okay, thank you, sir. We're gonna keep the bond at $1,000, okay, since you have the no bond hold. Good luck to you. Joseph William Kennedy.
Mr. Kennedy?
Then we have Alan
He's
Sander
approaching, Judge.
Semensky. Okay.
Mr. Kennedy is here present, Judge. I mean.
Here, give this to, Okay, Mr. Kennedy, you have count 1, loitering or prowling, bond set at $25, burglary of occupied dwelling, unarmed. We need to talk about bond. And then we have grand theft, sir, between $300 and $5,000. Bond's been set at $1,000. Any objection to probable cause?
I feel compelled to make one, Judge, because this probable cause affidavit is just so...
Tell me where it is when you read.
There's nothing in here. I mean, he says they responded to a burglary of a vehicle and that he matched the description, and that's all they give. They don't talk about what he was doing at the vehicle, whether he was attempting to break in, whether he actually broke into the vehicle, what color the vehicle is, what make and model the vehicle is, where the vehicle was located. Absolutely no details. No details given as to the description that Mr. Kennedy supposedly matched. Is it a white guy, a black guy, a tall guy, a short guy? Absolutely no details given whatsoever. I agree that there is a probable cause for loitering and prowling, but this probable cause affidavit is so bereft of any indications of anything that I would submit it fails to rise to the level of probable cause.
You're talking about counts 2 and 3, or 1, 2, and 3?
No, I think there's probable cause for count 1.
Okay,
But I don't think there's probable cause for count 2 or count 3. Nothing indicates as to what was stolen, any value of anything that was stolen.
Brian, you don't have the second report.
Yeah,
Oh, there's a second report.
The defendant entered the victim's property through
Oh.
an open gate of the driveway. The entire yard was fenced.
Well, yes, Mr. Linder is correct. I do not have the second report. If I could see the second report, that might change my argument significantly.
Check those defense report numbers on the
And it has videos.
If I could have just a moment, Judge.
That's okay.
No, I know they don't. That's what I'm saying. You got to see when they have a separate offense report.
Yes. Hold on one moment. We're going to go off the record for 1 moment and take a 2-minute break, okay?
Yes, ma'am.
Back. Joseph William Kennedy.
Your Honor, having reviewed the second probable cause affidavit, at this time I would withdraw my previous probable cause argument.
Okay, so sir, court's gonna find probable cause. Court does find, there's, bond, $25 on count 1. Count 2 we need to talk about, and count 3 is $1,000. State?
Your Honor, Mr. Kennedy was arrested a couple weeks ago on a drug paraphernalia trespass. He was ROR'd. It appears that's still pending. Considering this involves someone's home, I'm going to be requesting a $7,500 bond on count 2, no victim contact.
Okay, so the total, let me just get this straight. Total is $8,525 you're asking for bond.
Yes, ma'am.
Okay. Go ahead.
Judge, being Mr. Kennedy, unfortunately at this time he is homeless. He's 32 years old, been living here his whole life, but he does have a job. He is working at the West Star gas station. He does like cleanup for them, maintenance, things of that nature. He's been doing that for about months now. He gets paid about $8 an hour. Unfortunately right now, like I said, he's trying to save up to better situation, but he has really no sort of savings, nothing at all. He does have a mailing address as far as where he can receive notice, Judge. So I'd ask you to take Mr. Kennedy's financial resources into account in determining a reasonable bond on his behalf, Judge.
Okay, court's gonna do a $7,500 bond on count 1, or, I'm sorry, on count 2. $1,000 on 3, leave a 25 on 1. No victim contact, direct or indirect, with the alleged victim, SK, in this case. Thank you, sir. Versace Gianni Burgess.
What page is he on, Judge?
We're taking this out of turn. I'm sorry. We have someone here.
Oh.
Okay, what is your name, ma'am?
Tiana Jones,
Your relationship to Mr. Burgess?
the mother of his child.
Are you here today for support or to tell the court something?
His mom asked me to come this morning.
Okay.
For support and whatnot.
Okay, thank you.
Mm-hmm.
Can you spell your last name for the court reporter?
Jones.
Okay, Mr. Burgess, you have count 1, possession of weapon or ammo by a gang related felony. Count 2, distribute or deliver heroin. Count 3, probation violation or community control in violation of probation. I can tell you on counts 3 and 4, you're going to be held no bond. You are going before your division judge, who is Judge Andrew Siegel, on March 6, 2018 at 8:30 a.m. State?
Your Honor, in light of the fact that he's on probation for a firearm offense and is now unlawfully in possession of ammunition, I'd be requesting a $2,500 bond on count 1.
Okay, so $5,000 total bond on 1 and 2, and no bond on 3 and 4. Any objection to probable cause?
Well, I was hoping to find an argument about the gang-related evidence, but it seems to be present in the probable cause affidavit, so no.
Okay, the court's going to find probable cause. Any objection to bond at $2,500 on 1 and 2, since he has 2 no bond holds?
Judge, I do understand he has 2 no bond holds, $5,000, but Judge, he works at Taco Bell, so there's no way he's going to be able to come up with that $5,000. Would you consider setting something more reasonable regarding his financial resources on counts 1 and 2?
No. Okay, court's going to leave it at $2,500. Sir, you are going Tuesday on March 6th at 8:30 a.m. Okay, Judge Siegel, thank you. Good luck to you.
Thank you.
Good luck, sir.
Okay, thank you for coming, ma'am. Thank you. Alexander Semensky, you're welcome.
Mr. Semensky is here, present, Judge at Maine.
Okay, and then we have Rex Chendi Maldonado. Okay, are you Mr. Semensky?
Yes, Your Honor.
Okay, sir, you have an aggravated battery with a deadly weapon and a capious misdemeanor. You are going before your misdemeanor judge, Judge Christopher Pohl, on March 6th at 10 a.m. Bottom here. Okay, they put your no-show a calendar call for a battery. So you're gonna be held no bond on that charge. The aggravated battery with the deadly weapon, there's a warrant, state.
Your Honor.
Thank you. Okay, I've been handed a complaint affidavit.
This is, Your Honor, what I
And
provided
one's
the
been
court.
provided to the public defender, Mr. Reedy. Go ahead.
Your Honor, I provided the court the probable cause affidavit from count 2. The reason being, Your Honor, to document the other instance of alleged violence in these pending criminal cases, Your Honor.
So it was down-filed, as you're saying?
Yes, Your Honor. It was down-filed because the case father did not believe that the injuries the alleged victim sustained would satisfy the requirements of an aggravated battery. Which isn't to say that based on what is documented that the alleged victim did suffer some serious injuries. But noting more specifically, now we're here today because while out with that charge pending, Mr. Semensky is alleged to take a weapon, a large wrench, into a casino, essentially stalk a victim and strike him from behind the back of his head, causing serious injuries. It didn't matter that there was at least several people standing there while it occurred. With these allegations, Your Honor, and I would also note he has a warrant out of Dade County right now for a failure to appear on a DUI. It's a $3,500 bond. He has prior violence out of the state of New York in 2006, assault in the 3rd degree with intent to cause physical injury. Your Honor, frankly, my safety concern cannot be limited to just the alleged victim in this case, as you have an allegation in front of you that's pending that he attacked a neighbor for no other reason than over fruit from a mango tree. Your Honor, I'm going to be requesting a $50,000 bond on count 1, pretrial release with a GPS monitor, no victim contact.
Okay, sir, you're to have no victim contact, direct or indirect, with the alleged victim, Eddie Stodsdill, Stogsdill. That means no contact in person, on the phone, texting, through third parties, social media, liking anything like that. Do you understand, sir?
Yes, Your Honor.
Okay. Defense?
Judge, in speaking to Mr. Semensky, he's been in custody for a while. I believe he was extradited in New York. That's where he resides. He does AC work. From what he advised me, Judge, like he makes on a good week about $500 a week. So financially, he's not in a position to afford what the state suggested, a $50,000 bond. Judge, considering at this time, I do understand the allegations and the court's concern. However, at this time, Judge, I'd ask you to consider reducing the bond from $50,000 to $10,000 on Mr. Semensky's behalf.
Okay, thank you. Court's gonna set bond on count 1 at $50,000. There's to be no victim contact. GPS level 2. Thank you. Next one, Rex Chendi Maldonado.
Mr. Maldonado is here, present, Judge, with the Common Service of Public Defense.
Okay, Mr. Maldonado, good afternoon. You're charged with Counts 1 and 2, grand theft between $300 and $5,000. Bond set at $25,000 per count. And then you have petty theft, second degree, third offense. Bonds also set at $25,000. The court does find probable cause. State?
Your Honor, I believe pretrial has some information.
Pardon, I can't hear you.
I believe pretrial has some information.
The defendant was placed on pretrial supervision on the 10th of February. I believe after speaking with the state that this occurred on the 14th of February.
Okay, and what day was he put on?
The 10th of February.
Okay. It's kind of hard to hear with the speaker right here. That's why I'm asking you.
No problem.
Okay.
Based on the court's finding of probable cause, we're going to ask that his pretrial status be revoked in case 18-1703 CF10A. This court placed him on pretrial on the 10th, and he was told not to return to target on that case. This is the previous gentleman with the GPS.
Okay, so let me hear you with regard to bond. 1, 2, and 3.
Frankly, Your Honor, considering that he is out right now on 3 separate cases with a total of 6 grand thefts, he's gone to prison before. His history: 2016 grand theft, 19 and a half months state prison. 2014 felony theft, violation of probation, 19 and a half months state prison. 2014, 2 counts of felony theft, VOP, 19 and a half months. Grand theft, 2012, 18 and a half months. Robbery by sudden snatching, 2012, 18 and a half months. Burglary of a dwelling, 2010. And grand theft with a violation of probation. Dealing in stolen property, false ownership info and a pawn item, 2 counts, 09, VOP. Your Honor, I would admit, at first glance, these bonds would even seem excessive. However, based on his history, based on the 3 felony cases he's out on for the same types of charges, I believe they're appropriate.
Okay, this is what the court's going to do. The court is going to, in case number 18, or let me ask you this, sir, I'm sorry. Do you have any response to the $25,000 bond, sirs? There's 3 of them. Sir, you want the public defender to represent you?
Yes, ma'am.
Okay. All right, let's recall this case.
I know you're going to represent me.
Okay.
So I'll just
Right.
leave that until you're calling back.
Yeah. Ruben Dario Vega.
Mr. Vegas here, present, Judge in Maine.
And that gets attached, Michelle, to this. Okay, Mr. Vega, you have 1 count of grand theft between $300 and $5,000. Any objection to probable cause?
Based on Mr. Vega's statements, no, Your Honor.
Okay, court's going to find probable cause. Anybody want to be heard with regard to the $1,000 bond?
Judge, the only thing I'm going to be requesting is a phone order so Mr. Vega can get a phone contact to see, have his bond posted, Judge.
Okay. Okay, there's no return to the development, a point of view. He doesn't live there, does he?
No,
Oh,
Judge.
no, wait, it's the point of view eyeglass store, my bad. No return to the point of view. He actually lives by there. Eyeglass store. Bond will be kept at 1,000, thank you.
Thank you, Judge.
Devontae Malik Thomas.
Mr. Thomas, come on up, please.
Mr. Thomas, you have a violation of probation. On a felony case, your division judge set your bond at $13,000. You're going to be going before Judge Michael Rothschild on March 6th, which is Tuesday. at 8:30 a.m. If you can bond out on the $13,000, then you still have an obligation to go to court. Do you understand, sir? Okay, good luck to you. Desmond Lyles, remember that's Tuesday, sir. Judge Rothschild, 8:30.
Is he?
Present, Judge?
Okay, sir, you're charged with missile into a dwelling, vehicle, building, or aircraft. Any objection to probable cause?
He's out on a few things.
No, Your Honor.
Okay, the court finds probable cause. Let's talk about bond, State.
One moment, Your Honor. Your Honor, I'm going to be asking for a $10,000 bond, no victim contact, GPS monitor. First noting the allegations are that he threw a garbage dumpster with the approximate weight of 20 pounds against the front windshield of a vehicle where a juvenile female was in the car and had her infant son in the rear passenger seat. Also noting that Mr. Lyles is out of custody right now on a grand theft, he's out on bond. He also has a pending petty theft and resisting a merchant on a second
Okay,
case.
tell me his pending grand theft?
The case number?
Yeah.
Okay. 17-13184 CF10A.
Okay,
Did we get?
go ahead.
I've got one left.
She also had her infant son.
I don't think I'll need any more this morning. Great news. They made a great news. It's on top of the great news. What's the yellow? That's gross, because like you're gonna take them off and then you're gonna have like a new Barbie. That's perverse. Please, I can't.
Anything further?
Nothing from the state, Judge.
Okay, defense?
Judge, in speaking of Mr. Lyles, he's 20 years old. He's been in South Florida his whole entire life. At this time, he is working. He's basically supporting his family. He works at Home Goods. He's been there for 8 months now, making $8.25 an hour. Besides that, he goes to Florida Career College. He's on financial aid right now, Judge. He's studying. He wants to be a registered nurse. That's his goal. That's his dream. At this time, Judge, he's living in Hollywood with his grandmother and his mother. His mother, unfortunately, is on disability, and his mother is on disability. His grandmother is paralyzed. Mr. Lyles does help out financially and physically at the home with both his mom and grandmother. Judge, I do understand the court's concern with this allegation and the fact that he's currently out on bond. I ask you, Judge, to impose a $1,000 bond on this case plus standard or pretrial level 2, so that he could still be out there working, providing for his family, Judge.
All right, sir, the court's gonna order no victim contact, direct or indirect, with the alleged victim in this case with the initials GUU. That means no contact in person, through the phone, social media, texting, liking any pictures, or any contact through third parties. It's direct or indirect. Do you understand, sir? GPS level 2, no return to Sonny's Triangle. Bond's going to be set at $5,000. Court's going to leave the issue of his pending grand theft, whether that bond should be revoked, left to the division judge. Thank you. Giddle, Yethro, Green.
North Broward, I believe, Judge.
Thank you. Okay. Giddle, Yethro, Green. All right, then next one's Dennis Lewis Rimmer, and after that is Romaine Andrew Plummer. Pardon? He's coming up. They said 1 moment. I know it all blends sometimes. Okay. Mr. Green, you're charged with burglary of an occupied dwelling unarmed. We need to talk about bond. You also have an out-of-county hold for a felony, which you're being held no bond. On that case, that is out of Dade County for a grand theft case. State?
Okay.
Oh, any objection to probable cause?
No, Your Honor.
Okay. Sir, we have an attorney, Mr. Reedy, from the Public Defender's Office, who's here in the courtroom today representing you.
Okay.
Here you go, Ms. Patrice. You're welcome. Okay, anybody have any further comments?
No, Your Honor. In light of the no bond hold, I'd ask the court to set a $2,500 bond on the burglary.
Your Honor, he's out on a grand theft. He is entering someone's home while they're present, middle of the day. I'm asking for a $20,000 bond.
I think no matter what bond the court sets, it's going to be a moot point because Mr. Green is going to be held no bond. There may be more here than meets the eye based on my review of the probable cause affidavit.
Does he live at 434 Northwest 8th Street, Miami, Florida?
That's where my family stays. I don't stay there.
Okay, where do you stay, sir?
I don't have a place to stay right now.
Can you stay at your parents' home if you had to?
No.
Any place you could stay?
No.
Okay, this is what the court's going to do. No victim contact, direct or indirect, with the alleged victim, whose initials are JMC. That's at the address at the 701 Northeast 32nd Oakland Park, and no return to that address.
Okay.
Court is going to set bond at $10,000, sir.
Okay.
And you're not to return to the address. Thank you, sir. Good luck to you.
Thank
You'll
you.
be taken to Dade probably after this case is resolved or in the meantime. Dennis Lewis Rimmer. And then we have Romaine
Rimmer's
Plummer.
here present, Judge, and when you're ready, Mr. Rex Maldonado, I've already spoken to him, so whenever the court's ready to proceed on that, we're ready, Judge.
Okay. Where's that one? What is that turned over? Okay. This is the good one? Okay. Okay, Mr. Rimmer, you're charged with false ID given to a Leo. Bond's been set at $100. Count 2, drug paraphernalia possession, ROR, resisting an officer without violence, ROR, trespassing unoccupied structure or conveyance, ROR. You do have a violation of parole. You are being held no bond. The court does find probable cause. What do you want? What do we want to do with count 1? Okay. Want to leave it at 100 or ROR?
I'd rather him, I don't know when the parole board's gonna come and get him, Judge, or talk to him. I don't want him to do dead time on this, so I'd ask you to keep the bond in place at this time, Judge.
Okay, there's no return to the West Star gas station. You understand, sir?
System is resolved.
Yes?
Yeah, I can't talk. They kicked my key.
Okay, that's fine, sir. I'm sorry about that. All right, so court's gonna keep the bond at $100. Good luck to you, sir. The parole board will be
Would
in
you
touch
sign
with
a
this.
photo order?
Sure.
Thank you, Judge.
You're welcome. All right, we're gonna recall Rex Maldonado, and then after that is gonna be Romaine Andrew Plummer.
Mr. Maldonado, come on up, please.
And after Mr. Maldonado is Romaine Andrew Plummer and Jacob Wayne Tipton, and then David Brightswell. Okay, we're back at Mr. Maldonado. Chart has 2 counts of grand theft between $300 and $5,000, petty theft, second degree, third subsequent offense. Bond's been set at $25,000 per count for a total of $75,000, and we were talking about pretrial. Okay, go ahead, defense.
Judge, as far as the $75,000 bond that's currently set in place, and speaking with Mr. Maldonado, that's something that he's not going to be able to come close. He's 28 years old. He's not working at this time. He is going to school. He goes to Sheridan Tech. He just enrolled in their air conditioning program. At this time, he's living in Pembroke Pines with his mother, and his mother's retired, so that she's on a fixed income. So $75,000 is impossible for Mr. Maldonado. I'd ask you to consider, and I do remember what Mr. Lender said as far as his concerns, as far as why he thought it was appropriate, $75,000, considering the fact that he's currently out on a case. Judge, but $75,000 for him would be the same thing as no bond. So, Judge, I'd ask you to consider setting a bond of $5,000 on each count. That's still
How
over
much?
5 times what the $5,000 on each count. That's still over 5 times what the standard bond would be on a third-degree felony. I believe that is reasonable in this situation, Judge.
Hi, how are you? Okay, this is what the court's gonna do. The court is gonna revoke his pretrial in case number 18-1703 CF10A. Court is gonna set bond at count 1, 2, and 3 at $5,000. No return to Macy's and no visits to any pawn shops. Good luck to you, sir. Goes that way. Ronnie Andrew Plummer, and then we're calling Jacob Wayne Tipton, and then David Brightwell. Romaine
Mr.
Andrew
Plummer, State
Plummer.
President, he declined to serve as the public defender, Judge.
Okay, Mr. Plummer, you have a violation of community control. You're going before your division judge, Judge Merrigan. Judge Merrigan has ordered that you be held no bond pending a hearing before him on Tuesday, March 6th at 9 a.m. So that's this Tuesday at 9 a.m. Good luck to you, sir, okay?
All right, man.
Okay, Jacob Wayne Tipton, David Brightwell is next, and then Anthony Jason Cook.
Mr. Tipton is here present, Judge, at Maine.
Okay, good afternoon, Mr. Tipton. You have a grand theft between $300 and $5,000. Bond's been set at $1,000. Any objection to probable cause?
I'm sorry, Judge, who is this?
This is Jacob Wayne Tipton.
No, Your Honor, no argument, probable cause.
Court's gonna find probable cause. I can tell you there's no return to target. Anybody want to be heard with regard to the $1,000 bond?
My question is this: what was the value amount on the alleged items that were taken from Target, Judge?
$463.49.
Thank you, Judge. Judge, in speaking to Mr. Tipton, he's not going to be able to afford the $1,000 bond. He lived his whole life in Arkansas. He's relocated. He's been here now 1 year. He just got hired at a job. It's called Swisher Sweet Cigar. He's like basically their marketing specialist. I don't know if that's some sort of customer service, something like that, but he's telling me he's going to get paid about $15 an hour. He lives in Hollywood. He lives at a halfway house. He's been there for about 4 months. From what he says, he's still welcome back there. He's still going to live there. Still can receive all his mail there. Judge.
So what are you asking for?
I'd ask you to impose an ROR and impose standard pretrial release on Mr. Tipton's behalf.
See at 609 South Ocean Drive?
Yes, ma'am.
Okay, is there any apartment number attached to that, sir, or you just get your mail at that 609 address?
That's the halfway Serenity Ranch on that.
Okay. All right, state, any objection to ROR?
Yes, I didn't object to his
Or standard pretrial release?
Yes, I didn't object to his co-defendant because she doesn't have any pending warrants for failures to appear out of other states, and she doesn't have pending felonies out of other states. He was just arrested 2 weeks ago, just over 2 weeks ago in the state of California for possession of a controlled substance, 2 counts. He also has a warrant out of the state of Arkansas on a DUI for failure to appear November 30th of last year. And if he has enough resources to be in California 2 weeks ago and now back in South Florida now, then I don't think it's, a bond is unreasonable.
All right, let's talk about his ability to pay, Mr. Romero.
Judge,
what does he have in assets?
Oh, let me inquire. Judge, considering what Mr. Lender said, in that case, we're not going to be requesting anything. We're going to ask to leave the standard bond alone, ask you to sign a phone order so he can try and contact friends and family, Judge.
Okay, and there's no return to target, sir? At 5800 South University Drive, Davie, Florida. Thank you. David Brightswell, and then Anthony Jason Cook, and after that's going to be Quinn Gale.
Mr. Brightwell is here present, Judge, at Maine.
Okay, good afternoon, Mr. Brightwell. You have possession of cannabis under 20 grams. Bond's been set at $100. Driving while license is suspended. The court's going to ROR you on that. It's your first offense. You do have counts 3, 4, and 5 are capious felonies. You're going to be held no bond on those. And you have 6 and 7, which are capious misdemeanors.
So that these are out of there? Yeah.
Which are capious, I'm not telling you, which are capious misdemeanors, $1,000 and $500 bond. Want to be heard on probable cause, anybody? Okay, the court's going to find probable cause. Does anybody want to be heard with regard to the bond of $100 on one?
Judge, Mr. Brightwell is asking me to ask Your Honor if you would consider, since it's a cannabis offense, an ROR on count 1 as well.
Sure. Okay, so he has ROR, no bond, no bond, no bond, 1,500, so 1,500 total in bond.
Judge, he wants to know when's his court date.
It just says to be set.
To be determined.
Yeah. Does anybody have a court date?
What he's trying to say is it's not serious. I know.
Okay, Anthony Jason Cook.
Your Honor, my understanding is that Mr. Cook has private counsel, George Castratero. I am currently on hold with his office. If we could just put that on recall for a moment.
Might be issues.
Okay, maybe he wants it for this afternoon. Then we have Quinn Gale. And then Ernest James Walker.
Quinn Gale, Judge, I've been advised bonded.
Is that correct, commitment? Ms. Commitment.
Mr. Walker, you're going to be next. Come on up, please.
Did you read that? Read it.
Okay, Devin Richard Atwell.
No. Oh, sorry, Mr. Walker. Have a seat. Mr. Atwell, come on up.
Well, no, Ernest James Walker.
Yeah, he was up, but then you just called Mr. Atwell.
No, I'm saying that's the second name after him.
Oh, you didn't say, you just announced the name. So, all right. Come on up, Mr. Walker.
Okay, so it's Ernest James Walker, and then after that is going to be Devin Richard Atwell and Dwight Andre Scarlett.
Yes, Judge.
Okay, sir, Mr. Ernest James Walker, you're charged with robbery, no firearm or weapon. You need to talk about bond. Any objection to probable cause?
Yes, I do, Judge. If I could just get to Mr. Walker's report to refresh my recollection. Robbery. It doesn't appear as though he stole anything, Judge. The report indicates that he is inside the business. He selects a smart trim lighting kit. And while still inside the business, he's confronted by the manager. There's no indication that he tried to leave the business or walk past any points of sale. And if I'm not mistaken, and let me just check it again, I think he leaves the item behind and runs out of the store. So if I'm correct, let me just read it again because
Says the defendant stated he did not steal anything and ran out of the store because he was worried the store employee was trying to pin a charge on him when he heard the store employee yell, "Call the cops."
right, but that's not a robbery. He's not in the process of stealing anything. He's inside the store when he's confronted by the manager. And if I'm reading this correctly, and I'm sure the state can correct me if I'm not, he does not leave the store with the smart trim lighting kit, which would be the object of the robbery. Instead, once confronted by the manager, it says he becomes agitated and shoved the man and then ran out of the business. But I don't believe it says he ran out of the business with the item. So it could be a battery, it could be something else, but I don't see it as a robbery because he never had a chance to pay for the item. For all we know, he intended to pay for the item when he was confronted.
Okay, I'm tending to agree with them, Mr.
Your Honor, theft is stealing or endeavoring to steal. And no, I'm sorry. I think based on the facts, it was not his intent to pay. If it was his intent to pay, why would he punch the employee who just asked to see what was in his bag? It wasn't a shove. He punched him.
But that's not...
Shoved him.
No, Your Honor. It says the defendant became agitated, punched Orderino on his chest, and shoved him.
Where is that?
Before it says he shoved him.
Later on, the story changes a little bit, Judge.
No, the story might change from the defendant.
Well, it says shoved, and then it just says shoved and punched. No, I understand, Judge. But it's still not, even taking the state's argument at face value, that still does not amount to a robbery. He has to steal something. He's not, there's no, and for the state to subjectively say that the reason he shoved or punched the manager of the store is because he intended to steal this item is a leap of faith and an assumption. We don't deal with assumptions here. We deal with evidence. I think it also indicates that from Mr. Walker's later statements, he was concerned because he heard this man say, "Call the cops," and that's why he pushed him and ran, not because he intended to steal anything. So there's no indication here of any endeavor or attempt to steal. He's inside the store with the item. He never leaves the store with the item. He's confronted inside the store, and that's not evidence of a robbery.
And it's in his bag.
Your Honor.
It's in his bag.
It doesn't matter where it is.
Of course it does. Your Honor,
No, it doesn't.
We deal in common sense also. And I'm sorry, based on what the victim and witness is telling law enforcement, because frankly, Mr. Walker's statements are self-serving. Dealing with the witness victim statements, there is certainly reason to believe that Mr. Walker was endeavoring to steal. And he doesn't have to get out of the store for a theft. There is no attempted theft. And
There's no theft at all, and there's no robbery at all. And for the state to say, well, we use common sense, well, that's fine.
Well, let Mr. Linder, are you finished, Mr.
Oh, I thought he was
No, I
finished.
wasn't.
Oh, I'm sorry, Eric. I thought you were finished. Please go ahead. I'm sorry.
even if you believe what Mr. Walker saying, well, I thought he was going to try to pin a charge on me. Well, if that's what you think, then you drop the item. Fine, I'm not going to buy your item. That is what a reasonable person would do. A reasonable person who is not has no criminal intent is not going to punch the employee in his chest unless he got caught before he was able to leave the store with it and wanted to make his escape. That's a reasonable explanation using common sense.
Are you finished now, Mr. Linder? Taking everything Mr. Linder says at face value, it's still not probable cause. Because what Mr. Linder is asking this court to do is to somehow see into the future as to what would have happened had Mr. Walker not been accosted by the manager of the store, whose statements, by the way, are also self-serving. Mr. Walker stated, "I did not steal anything. I ran out of the store because he was worried the manager was trying to pin a charge on him." And not only does he say he did not steal anything, this probable cause affidavit quite clearly points out he did not steal anything. And for the state to ask this court to go out on a limb and assume what might have happened in the future, which is not what we do in the law. We do not assume what's going to happen in the future. The state has a burden of proof here. It may be a very low standard of probable cause, but they still have the burden. And the four corners of this probable cause affidavit may sustain probable cause for other charges, like a battery, but it does not sustain a charge of robbery.
And I would even note in the robbery statute, Your Honor, 812.
Well, that's what I'm looking for. I'm looking for the
taking of money or other property which may be the subject of larceny.
But there's no evidence of a larceny. There's no evidence of a theft. There's no evidence of a robbery.
I know that's Mr. Reedy's opinion. But
It's not.
Excuse me. Excuse me. I know that might be his opinion, but what we have here, the allegations are, he's walking around with a bag, not in his hand, a bag with merchandise. An employee approaches him and says, "May I see the bag?" His response isn't, "Yeah, sure, because I'm going to pay for it." His response is, punch the employee, shove him, runs out of the store. That is not evidence of someone endeavoring to steal for probable cause?
Again, the state is asking the court to go out on a limb on this so that it can saw the branch off behind you, Judge. This is absolutely no probable cause to support a robbery. It doesn't matter if it was in a bag, if he had it in his hand. The evidence that's required, there has to be evidence that he intended to commit a theft, that he endeavored to commit a theft. And that evidence isn't here.
You have to show intent.
And the fact that his response when he was just...
You don't have to yell.
Your Honor,
I
well,
understand
both
your-
sides are.
No, I understand.
We love a good debate, Judge.
I know you do. Both of you do. Go ahead. Let's talk about the intent.
His actions show his intent.
Okay.
His intent is, again, if his intent was innocent, there's no reason to punch an employee and run from the store.
But he offers the explanation as to why he did that. He stated he did not steal anything and ran out of the store because he worried that the manager was trying to pin a charge on him when he heard the manager yell, "Call the cops."
And, Your Honor, that has to be, an explanation also has to be a reasonable explanation. If he just said, take the property, fine, I'm not trying to steal anything, keep it.
Well, he didn't.
He punched him and ran. That's not reasonable. Just because he says that's why he did it, doesn't mean the court should accept that because it's not reasonable.
Anything further?
No, Judge.
Okay, the court's gonna find probable cause for battery. Okay, so let's talk about bond. I am gonna tell you there's no victim contact, direct or indirect, with the alleged victim with the initials OKO. And sir, under no circumstances are you to return to AutoZone, you understand?
Yes.
Okay, let's talk about bond.
Yes, Your Honor. I'm going to be requesting a $5,000 bond in addition to the court's orders. 2016, resisting with violence. 2012, strong arm robbery. He violated probation.
Hold on, I'm writing it down. 2016.
Resisting with violence.
With violence.
2012, strong arm robbery with a violation of probation, 2.5 years state prison. 2012, insurance fraud with a violation of probation, 30 months state prison. Aggravated battery against a pregnant female, 2009 with a violation of probation. Theft, 09. Theft, resisting without violence, and resisting a merchant in 08. So he's had this practically the same exact offense in the past, violence in the past, crime of dishonesty in the past. He's gone to prison for the same exact offense. And then when an officer was acting within a legal duty, he responded with violence in his last case.
Okay, what's his address? 5224 Northwest 25th?
2222 Northwest 59th Way.
What is
Lauderdale,
it?
Florida. 2222 Northwest
Hold on,
59th Way.
2222.
Northwest 59th Way. Lauderdale, Florida. 33313.
Hold on, because I'm writing it down.
Yes, ma'am.
Okay. 33.
313.
Any apartment number?
No, ma'am.
And who lives there with you?
My mom, my 2 kids, and my brother.
How long have you been living there?
Since August of last year.
All right, defense?
Judge, what we'd be asking for, the court found probable cause for a misdemeanor battery. That's what we're dealing with. The standard bond on a misdemeanor battery is $100. I do understand Mr. Lender's concerns as far as his record. So what I'm suggesting, Your Honor, is a $1,000 bond on Mr. Walker's behalf. That's 10 times over what the standard bond on this case. I believe under these circumstances, that would be reasonable, 10 times over what a standard bond is. And speaking to Mr. Walker, he's working right now. He works for JT Construction. He makes approximately $80 a day. He's 27 years old. He lives with his mom and his kids right now. Judge, right now, his mom, from what he advised me, is a teacher at a daycare. So funds are limited, and whatever funds they get, supporting the household, supporting the kids. So that's why under these circumstances, financial resources are very limited. I'd ask you for a $1,000 bond on Mr. Walker's behalf.
Okay. No victim contact, direct or indirect, with OKO. No return to AutoZone. GPS level 2, open schedule, $2,500 bond. Good luck to you, sir.
Your Honor, we could recall Mr. Cook, if you care to.
Which one's that? I'm sorry.
He's the one that I was in touch with, the private attorney.
Okay, I'm sorry. That is Mr. George Kester. Okay.
You're trying to contact your attorney, sir.
All right.
Your Honor, I spoke with the attorney, Mr. George Castriano. He indicates that he does not represent Mr. Cook, and he will not be appearing on his behalf.
Okay.
So I don't know if Mr. Cook wants to avail himself of the services of the public defender or what he would like to do at this point.
Oh, that I have no idea why he's not your attorney.
Okay, we can hear you.
Formally retained. Okay.
Show him the PC. This is his thing.
Judge, I'm speaking with Mr. Cook. I told him to, he has the option of applying right now for a public defender. He has advised me that he wants to try and contact Mr. Cook to clear this mess up, so then Mr. Castronero can represent him, because according to him, he believes that Mr. Castronero is on his case. He's used him in the past. He's going to be using him, so he didn't know why he said that, but he wants to try and call him, so he wants this case reset for the afternoon, Judge.
No objection from the state?
Yeah, I don't have a problem.
All right. They'll bring you back here at 1:30, okay?
How do we know he's gonna be able to call him?
I'm,
Does he have his number?
I'm more than happy to call him back if Mr. Cook has some indication as to what it is that he would like me to tell him.
Okay, why don't you get him, why don't we just go off the record for a moment, and you can, speak to him, okay?
All right, okay.
Hector, he's gonna be calling you.
Yes, sir.
This is gonna be Devon Richard Atwell, then Dwight Andre Scarlett, and then Kenneth Goodman. Okay, so this one right here.
I don't have any of these. Unless they're under here. Yeah, they're under here. I know. Damn. I'm like, nobody's reading the PC.
Judge, I just spoke with Mr. Cook. He gave me an alternative attorney that I could possibly contact.
All right, so let's
So
reset it for the afternoon.
that'd be fine, Judge.
Devon Richard Atwell.
Mr. Atwell's here present.
Okay, sir, you're charged with petty theft, first degree, between property value between 100 to 300, ROR on that, fraudulently utter a false instrument, bond set at $1,000. Any objection to probable cause?
Judge, I'm not sure that a receipt is a false instrument. It says he provided them with a Walmart receipt from another location. But I don't know that that's a forged document.
Okay, you're talking about count 2?
Yes, Judge, I'm talking about count 2 specifically, yes.
It doesn't have to be forged. Whoever utters and publishes as true a false, forged, or altered record, deed, insurance,
Yeah, I think
or other
that's-
writing mention, knowing the same to be false. Well, he knew that this was not a receipt from a actual purchase.
Yeah, I'm inclined to agree.
Okay, so the court's gonna find probable cause. Anybody wanna be heard with regard to the $1,000 bond?
Judge, Mr. Atwell is asking me to ask the court if you would consider an ROR on his behalf, a straight ROR.
State.
He was arrested in Glades County last year on a failure to appear.
For what?
Looks like battery. He had a battery last year in Orange County. And,
He has an Orlando address and a Fort Lauderdale address.
there you go.
Where does he live, Mr. Romero?
Judge, he lives here in Broward County. The particular address, what is it?
4844 Northwest 24th Court, Lauderdale Lakes, Florida. Zip code 3313, apartment 235.
It has Fort Lauderdale. Will your mail get to you?
Yes, ma'am.
33313?
Yes, ma'am.
Madam Clerk, do you have his address as Orlando or Fort Lauderdale? Okay, I didn't know that. You don't have a computer there? Is there any way that you can check it?
Thank you, Willie.
Okay, State, anything further? What are you requesting, keep the bond in place?
Either that or at least pre-trial, but not a straight ROR with an arrest last year for failing to appear in court.
Would you rather the address say Lauderdale Lakes or Fort Lauderdale, sir?
Lauderdale Lakes?
Yes.
Three 33313?
What's your zip code?
33313.
Okay, so it's 4844 Northwest 24th Court, apartment 205, Lauderdale Lakes,
No, apartment 235.
235,
Yes.
Lauderdale Lakes.
Correct.
Okay. Okay, anything further?
Not at this time, Judge.
Okay, court's gonna put him on ROR, standard pretrial release. Tell him about having to report within 24 hours of his release, okay? Tomorrow,
Judge.
Saturday. Dwight
Tomorrow,
Andre,
oh, Judge, if he doesn't get released by today, then he'll have to be
24 hours
report
of
by Monday.
correct. I mean, 24 hours of release would be Monday, okay? Dwight Andre Scarlett. Obviously,
Mr. Scarlett's
pretrial
your
is not
present,
open
Judge?
on the weekend. And then we're gonna call Kenneth Goodman. Okay, Mr. Scarlett, you're charged with criminal mischief, over $1,000. Bond set at $500. Any objection to probable cause?
Your Honor, the only evidence of probable cause here is that it's a mere presence argument. Mr. Scarlett is seen in the area, a loud noise is heard, no one sees him break the window, no one sees him throw anything through the window, there's no physical evidence connecting him to the crime. It's just that he happens to be there. Without more, I would argue that there is no probable cause because in order to find probable cause, the court would have to assume facts that are not contained within the probable cause affidavit and rely on pure circumstance. And that is not enough for probable cause.
This thing is so hard to read. I read it earlier, hold on. I called Plantation about this. I mean, the font is like a 4. Okay, State.
All right, he's not just in the area, he's literally walking between the witness's residence and his neighbor's / victim's residence. He's right there in the area at 8:30 at night, Your Honor, where it occurred. That gives grounds for probable cause. Also considering he ran from the witness.
I would just say, where is there any evidence in this probable cause affidavit that Mr. Scarlett broke this window?
want to respond to that, or?
Say it again. He was right there when it happened, and then ran from the scene. Your Honor, it's probable cause. It's circumstantial, but circumstantial has just
I
as much weight.
understand. Okay, the court is gonna find probable cause. Sir, you are to have no contact, direct or indirect, with the alleged victims in this case, who I have as Clyde Buchanan Jr. That means no contact, phone calls, in person, texting, blogging, through third parties, social media. Do you understand, sir?
Yes.
Okay, all right, and what are you requesting as far as bond? I'm sorry? Did you tell me what you were requesting with bond?
No, I didn't,
Okay.
Judge. Judge, I'd ask you for mitigation purposes, take into account what my colleague argued.
Sure.
I don't even know if this kind of case is gonna be filed, if it's gonna get past the case filer. Judge, I'd ask you to consider setting up a $100 bond on Mr. Scarlett's behalf. He did give me the phone number of his mother, and with the $100 bond, I believe she'll be able to make that.
Okay, $100 bond, thank you. Kenneth Devon Goodman, and then Kenneth Calvin McDonald. We have, Goodman? Is there a Kenneth Devon Goodman?
He's approaching.
Okay, Mr. Goodman, come on up, sir. Charged with 1 count of possession of cocaine, $1,000 bond. Count 2, possession of drug paraphernalia, $100 bond. Resisting an officer with violence. We need to talk about bond. Any objection to probable cause?
No, Your Honor.
Okay, court finds probable cause. Let's talk about the bond on 1 and 2 and 3. I'll let the state go first because we actually need recommendation for 3.
2016, possession of cocaine. 2016, possession of cocaine. 2013, introduction of contraband into detention facility. Possession of cocaine. Loitering and prowling with a VOP. Possession of cocaine. 2012.
So what are you requesting for bond?
Your Honor, I'll be requesting a $500 bond on count 3.
Okay, so $1,600 total?
Yes.
Okay,
Judge, Mr. Goodman says he can't afford $1,600 bond. Unfortunately, he's homeless at this time. He's not working. He doesn't have a mailing address. He's been here his whole life, and he can't meet any sort of monetary bond. Would Your Honor consider releasing him on standard pretrial?
I mean, he took off running. He failed to appear previously. They had to get the K-9 units out? No. This is what the court will do. $500 bond on count 1, $100 bond on count 2, and $400 bond on count 3. Total of $1,000. Thank you. Kenneth Calvin McDonald.
He's here present, Judge, I mean.
Okay, Mr. McDonald, good afternoon, sir. You have KPS felony. You have a no bond hold on counts 1 and 3. Count 2 is a KPS felony as well. And count 4, you have a KPS misdemeanor where the bond is set at $250. You are going to be going before your division judge, Judge Barbara McCarthy, this Tuesday, March 6th at 8:30 a.m. And it says status ICC hearing with regard to Division MS, that's the KPS misdemeanor for $250, is March 16th, 2018 at 10 a.m. Anybody want to be heard on anything?
No.
Consent is
No.
no bond holds, no, Judge.
Yep, okay, thank you. Antoine, Damon, Johnson,
Mr. Johnson's approaching, Judge.
and then we have Phillard Leonard Santoro. Is he,
Mr. Santana, I think he's still on medical loan, Judge.
is that a medical loan, Mr. Santoro?
Didn't see a booking photo when I looked, so I imagine so.
Okay, so we're gonna assume he's still on medical loan. And then we have Antoine Demond Johnson.
Yes, he's here.
He bonded?
Mr.
Okay,
Johnson
he
bonded?
bonded. Good
Awesome.
luck to you, sir, okay?
Good luck, sir.
Robert Walker is our last case.
Mr. Walker's here at Main, Judge.
Okay.
How you doing? How you doing, ma'am?
Very good, sir. You have a loitering or prowling, $25 bond. You do have 2 violations of probation or violation of community control. It appears to be a violation of probation before Division FK, who is Judge Andrew Siegel. And you are going before your division judge on, it says March 5th, which is this Monday at 8:30 a.m.
Is there any way we can take care of this loading and Friday, man?
I'm not gonna take care of it with violations of probation, sir, no.
What
You
does
wanna
violations-
ROR 'em, I don't care.
Won't get credit for time served if you
Well,
do
the
that,
court can
Judge.
take judicial notice, but it's up to you guys, it's up to him.
What happened? What you say,
What do
ma'am?
you want me to do on the loitering and
ROR
prowling?
you.
But he's gonna be held no bond, it's up to him.
Judge, he's saying he wants an ROR, Judge.
Okay, court will ROR 'em. Court does find probable cause. All right, thank you very much. Good luck. That's it, thank you.